as you have heard, one of the reasons I'm standing up here talking to you is because I've sat in the chair and done what you do and have been doing it for 30 years. So, seen a lot. It's been, shall we say, interesting the last 5 years in our business. And it really does feel like the more it changes, the more it stays the same. Because all that's happened is that the real has come back into real estate. Remember back in the olden days when it was 32% ratios on income for real property, housing, and then 44% ratios for income to see how much you could qualify for a loan? And then it was 100%, then it was 125% no money down stated income loans. What were we smoking and sharing not that day, right? So we're adjusting. The market is going right back to where it would have been if you look at historical norms over the last 50 years in terms of values. But for the youngsters who have only been in this business for 10 years, this is a cataclysmic change. And for us, we're just going back to the good old days, such as they were. We defend brokers. We do lots of defense for brokers and have since we founded the firm. What's happened as a result of the amount of claims that are occurring is that insurance companies are denying coverage requests. And so now we've increased the practice to bring claims against the carriers for those bad faith denials of coverage. And that's what this presentation is about. It's not so much the risk management of a practice or any of that good stuff, but it's about E&O coverage, which is, if I can get it to work, there we go, that thing that you love to hate. E&O coverage is really important. It's a critical part of any practice because it's catastrophic loss insurance. It's like major medical. You don't need it until you need it. And when you need it, you really need it. So imagine your joy when you tender a claim and it gets rejected. What did you pay all those premiums for? There are 4 main categories that I want to go over with you all today. And they are about the duty to defend, the duty to settle, what cumulus counsel is and what it means for you, and what a rescission of a policy is. And a rescission is different than a rejection of a claim, and I'm going to talk about the difference. So when you leave, you ought to be able to understand really well these 4 concepts as they relate to your E&O coverage. And then you'll understand what I mean when I talk about bad faith. Because bad faith is the shorthand version of what the claims are that you may have against a carrier if they violate any of those duties or unfairly rescind. So, let's begin at the beginning. What is an E&O insurance policy? It's a contract. And just like every other written agreement, it's got all of those express provisions. You pay me a premium and we will provide you coverage if a claim comes, if it's this kind of a claim. We won't provide you coverage if it's this kind of a claim, right? It's a simple written agreement. Except in California, because insurance is insurance, it's treated a little bit differently. And we're going to talk about some of those differences today. Now, I said earlier that it's a written agreement. And so you have all of those standard written provisions, but what about the unwritten provisions? And there are implied portions of an insurance contract, just like there are implied portions of any contract. And the big one when it comes to insurance is the covenant of good faith. Pretend it is set in stone. It is just as valid and just as present as any of the written provisions of an insurance contract. And what does it mean? It means you can't enter into a contract and then lie and cheat and steal your way out of it. You have to deal with the person in which, or with whom you have a contractual agreement fairly. And it sounds really simple. And it's like common sense. It isn't that common. So there are several duties, there are several obligations, whether they're expressly provided for in the written insurance contract or not, that are key points for you to be able to recognize and understand. And the first is that the insurance contract requires the carrier to defend. You get superheroes on your side. That's supposed to be the lawyers. Remember, the insurance policy is we will defend you and indemnify you. We will defend and we will pay a claim. But since we have the obligation to defend, and since it's our money that's going to be used while we're defending you, guess what? We get to pick the lawyers that will defend you. And that's called panel counsel. And so you get the insurance company's hand-picked legal team, such as it is. Generally speaking, that's not such a bad thing. But there are circumstances when it's not such a good thing. We're going to delve more deeply into all of these, but I want you to get an overview first. The second portion of an insurance contract is the duty to settle. In essence, the insurance company has an obligation to hand money over to a plaintiff. It has a duty to settle a case. If not settling that case, puts you, the insured, in jeopardy. Now, like all good things, there are strings attached to it. When does that duty arise? How can it be met? How can it be avoided and not breach the contract? That's what we're going to be talking about in greater detail. The other thing is that an insurance company isn't supposed to do this wonderful thing of tell you you're getting one thing, and then when you call up and ask for it, say, oops, we're going to rescind the policy, sorry. Rescind the policy is not the same as reject the claim. It's mulligan do-over, we're going to pretend the contract was never entered into in the first place. How do they do that? Why do they do that? That's what we're going to talk about in greater detail. When an insurance company doesn't defend, doesn't settle, or rescinds in bad faith, they have breached the covenant of good faith and fair dealing, just like every good old Snidely Whiplash would. Those things give rise to a claim that you have to assert in court called a breach of the covenant of good faith and fair dealing, which in shorthand is bad faith. So when you hear the phrase bad faith, it's not because they have cheated on you, it's because they have cheated you out of something. Insurance company contracts are different than normal contracts. Insurance companies are deemed to be quasi-public agencies. They're private companies, but they are deemed to fulfill a critically important public need. And as a result, an insurance contract is different than a normal contract. And only in the insurance context can an insurance company breach of contract claim give rise to tort damages. And this kind of tort is a legal tort. It is not the chocolate kind. So, tort, what the hell does that mean? Is it some Latin word? Frankly, I don't know. But think of the law as broken down into three main categories. There's criminal law, that's where they give you pretty stainless steel bracelets and you go to the Gray Bar Hotel. There's contract law, where there is a written agreement. And then there is everything else. Probate, personal injury, auto accident, defamation, slander, fraud, negligence. All of those claims, they don't come out of a contract. You don't go to jail for them, so what are they? They're torts. Key differences between contract law and tort law include, under tort law, you don't get attorney's fees if you win. In fact, you don't even get to claim attorney's fees at all. Attorney's fees only arise if there is a statute that says you get them, or if you have a contractual agreement that says you get them. So if you have a breach of contract claim, you can assert the right to attorney's fees if the contract provides for them. If you have a tort claim, you don't get to assert a right for attorney's fees. And anybody who's had a $50,000 claim that's generated $200,000 in attorney's fees understands that the fees are the tail that wags the dog. So it's really important to find a way to recover them. And in America, everybody pays their own. In England, the loser gets to pay. Whoever loses. So imagine when a plaintiff brings a claim, they want to make sure they've got a righteous one, because if they lose, they pay not only theirs, but the other side's as well. That's not the case here. So, what's another difference? Another important difference is the statute of limitations. In a contract context, the statute of limitations can be 4 years. In a negligence context, it's only 2. So, if you want to bring a negligence claim or a tort claim like bad faith against the insurance company, do you have to do it in 2 years if it's also a breach of contract claim? And the answer is no, you get to wait 4 and still be able to claim the tort damages. And how is that different? Because in a breach of contract claim, this is Law School 101, but it's really important stuff. In a contract claim, your damages are the benefit of your bargain. I entered into an agreement. You were going to give me all of the apricots off of the tree. I was going to give you 20 bucks. The benefit of my bargain is all of the apricots from the tree. So if you breach the contract, I can estimate how many of those apricots there were and how much money it cost me to replace those apricots, right? That's the benefit of my bargain. In a tort claim, the damages are anything proximately caused by the injury. So you're driving down the road and you get T-boned in an intersection. The cost of repairing the car is $2,000. The cost of breaking your arm or fixing your broken arm is another $2,000. $4 grand. Except you were a concert conductor. And the arm that was broken is the one that holds the baton. And now you cannot lift your hand higher than this, even with full medical repair. All damages proximately caused include lost wages for the remainder of your life. So is that different than benefit of the bargain? You betcha. And in a tort claim, you get those proximately caused foreseeable damages, but you don't get them in a contract claim. So imagine that apricots are Superman fruit. And if you eat the apricots, you get superpowers and you get to, stop bank robbers and get paid for it. You don't get those lost wages on the contract claim because all you get is the value of the apricots, not the value of lost work from the apricots. Does that make sense? So you can imagine that if you have a tort claim that you can bring against an insurance carrier for bad faith breach of contract, and that tort claim includes lost profits because you can't conduct your business without insurance, and you can reasonably calculate what the value of that business was, that's an impressive amount of damages to be able to put in front of a finder of fact at a trial that gives you leverage in the negotiation of a settlement or gets you a reward for all of the damages that have been proximately caused by a bad faith breach of the contract. So the tort damages, contract statute of limitations, all those things are critically important in the insurance company context. One more thing. Punies. Everybody loves punitive damages. Everybody loves to try to sue for punitive damages. It's those exemplary things. The insurance company was bad, and it has a long history of being bad. And so now we're going to punish it. Not only are they going to pay for the conductor's arm, but because we can show that they have rejected the last 15 auto accident cases in bad faith, all on the same premise, all designed to save them from having to spend any money for which they collected premiums, to punish them, a jury can award $10 million in addition to the lost earnings from the conductor. So, the punishment factor, again, only permissible in a tort claim. You don't get punitive damages in a contract claim. So, bad faith breach of contract is a blending of those two things that is unusual in any other contract context. So far, so good? All right. Now, we talked about 3 major categories of bad faith claims. 1, 2, 3. The duty to defend, the duty to settle, and the obligation to not unfairly rescind. Remember I said we were going to dive deep? Now we dive deep. The duty to defend is broad. It is broader than the duty to indemnify. Huh? You get a claim. You knew or should have known that the mold was in the kitchen, the living room, and the upstairs bedroom. And by the way, that the foundation was crumbling because you saw the crack and you didn't even bother to disclose it at all. Except if you knew, that's an intentional misrepresentation. If you should have known, you were merely negligent for not discovering it or not disclosing it. Those are 2 very different claims, because you knew and didn't disclose is an intentional fraud. You should have known and didn't disclose is merely negligence. Intentional torts are not coverable by insurance in the state of California as a matter of public policy. We will not let you get insurance and allow you to intentionally deceive and then use the insurance to pay the damages from that deceit. And that makes perfect sense. And what insurance company do you know would ever want to take the risk of having to pay for your intentional misconduct? Not going to happen. When the claims are both made in a single complaint and you get coverage, what's the carrier supposed to do? Defend one but not the other? Or defend both? Or defend neither? In California, the law is they defend all of it. That's pretty cool. Well, what about claims that have no basis in reality? Like, you stole my $50,000 diamond pin stick at the Sunday open house. Or you poisoned my dog at the Sunday open house. And now I have suffered emotional trauma because my little Pekingese was very precious to me. Okay, you get sued. But here's a better one and a more realistic one. I am the owner of a piece of real property. I have gone into foreclosure. There has been a short sale. I refuse to move out. I get evicted. Actually, there's been a foreclosure sale. I refuse to move out. I've been evicted. You are the listing agent for the bank. You're doing a clean out. And of course, what was left in the house when I was evicted was my $50,000 diamond stick pin, or my precious goods, all of my treasures that were in the attic that the Antique Roadshow has come and appraised, and now they're gone. One man's junk is another man's treasure, right? And it's all your fault, by the way, because you are the sleazebag agent that's in charge of all of this. So you tender that claim to your carrier, and it says, denied, because theft is an intentional criminal act not covered by the policy. That's when you call me. Because the insurance company has to defend a claim even if it's groundless or if it's false. And how would you know if a claim is false at the time it's made? You don't. You have to go through the trial to determine whether the claim was false or not. So, my treasures have been stolen. It's all your fault. When do you know whether it's true or not? At the end of the trial. So, do you get the coverage from the beginning of the trial, or do you have to wait for the end and then you ask for the insurance company to reimburse you the $150,000 you just spent? You get it from the beginning. And if it's proven that you took the diamond stick pin, you get to reimburse the insurance company. So, multiple claims, right? You've killed Muffy, you've stolen my diamond stick pin, you took the antiques out of the attic. All of those are intentional claims. Oh, and by the way, you were negligent when you showed the open house because somebody else broke a window. Who knows, whatever it was. So you've got 17 claims, all of which are intentional fraud, misconduct, criminal acts, and one claim of negligence. Does the insurance company have to defend the whole kit and caboodle? Yep, they sure do. And you'll get claims denied because of the nature of the damages that are being asserted, or you'll get a complaint that says you intentionally failed to disclose. They left out the or should have known. They only say you knew and didn't disclose. Well, every now and then, some defense lawyers have been known to pick up the phone and call plaintiff's counsel and say, you know, perhaps you should amend the complaint and say knew or should have known, because the addition of that little tiny phrase puts you within coverage. Plaintiff's lawyers love that idea because now you've got a deep pocket, the insurance company standing by to write a settlement claim. Defense lawyers like that idea because now they're going to get paid by the insurance company and they don't have to worry about getting paid. And what plaintiff lawyers don't understand is that defense lawyers will grind them into the ground because now they have someone who can pay them to do it. So plaintiff's lawyers will either be very smart or very stupid about how they put a claim together that will get you in or out of coverage. So it's really important to look carefully at what the policy covers and what the complaint covers. Because if you have a complaint and it doesn't allege a negligence cause of action, the insurance carrier will say, well, you know, they've said that you breached your duties of disclosure in this REO transaction. So no coverage, it's all intentional misconduct. They say you didn't disclose that there was a $50,000 termite report. And now all of a sudden, they've got to spend all that money. And the complaint is very clear. And it even attached the purchase agreement to the complaint. So the insurance company wants to limit its review to the pleading. But then you say, well, wait a minute, time out. Take a look at addendum 2 that they did not attach to the complaint that says we're giving them a $15,000 credit for the $50,000 termite report that they acknowledged having received and read. So how could it be that if they've received it and read it and got a credit for it, that it wasn't disclosed to them? And the insurance company will say, well, it's not in the complaint. We only have to insure what's in the complaint. Or deny coverage based on what's in the complaint. To which you get to say, nuh-uh. Because it's any fact that the insurance company reasonably discovers in the investigation of the claim, if there's a possibility of coverage, you're entitled to it. It doesn't mean that they have to pay indemnity and a judgment if you lose, but if there's a possibility of coverage from any fact related to the claim, they have to defend. We have had occasion in the last 18 months alone to represent a brokerage company that had TOPA Insurance as its E&O carrier on a case that had 5 different transactions involved in it, and TOPA denied coverage, and we settled the claim, and then we sued TOPA and got $1 million for the customer. And I thought, you know, that could be a fluke, and every now and then you just get lucky, except within a year, Scottsdale Insurance did a similar thing for a different client, and it got nailed for 6 1/4. The broker's injuries in these cases were less. The settlement turned out to be a benefit to the brokerages in those claims. Does it happen all the time? No. Does it happen that you'll get 60 cents, 90 cents, 100 cents on your dollar? 85 to 90, I would say, most of the time, if you've got a righteous claim. But remember those punitive damages? TOPA rejected a similar claim for the same broker about a year later. And we sued them again. And we're going to show the history of TOPA's denial of claims as a pattern and practice. And what do you think a jury is going to do to an insurance company against a struggling brokerage in California? I'll be happy to see how that one turns out. Okay, so you've been sued and you tender the claim to the insurance carrier. Remember, I've talked a lot about there are some claims that are covered and some claims that are not covered. So how does the carrier communicate this to you? It issues a reservation of rights letter. And reservation of rights, is that some fancy term? No, it actually is just exactly what it sounds like. We reserve the right to not pay an uncovered claim, even though we are defending all of them. Our defense of all of the claims does not necessarily mean we are responsible for paying a judgment on all of the claims. Again, makes perfect sense. In fact, it makes so much sense that if an insurance company doesn't give the reservation of rights, they are deemed to waive it. And that means you're able to rely that they are going to cover everything, whether it would have been covered or not. So what does that mean? It means that every claim that is submitted will get a reservation of rights letter. Because they can also say in their reservation of rights letter that we haven't done the full and complete analysis and we might find something else different. And if we do, and we can come up with another way to not have to pay the claim, we will later. So they'll find a reason of maybe 10, cite to the one reason, and they're okay. But if they don't issue the letter, they're screwed. Here's the downside of an insurance company issuing a reservation of rights letter. Well, there's a bunch of downsides, but I want to go into one more thing first. The reservation of rights letter feels like, seems like, sounds like, I'm hedging my bet. We'll insure you, but. And that's exactly what it is, on purpose. And again, once they have said, we will defend you, they will pick their lawyer to do so. Whether that lawyer has the skill to do it or not is not the insurance company's concern. It's yours. What the insurance company does when it picks panel counsel is finds a firm that will enter into what are called litigation management agreements. And those are contractual agreements that says, Dear Joe Blow of Dewey, Cheatham, and Howe, we're going to give you 90% of your business from our insurance company to defend our customers. You're going to give me a discounted rate. You're also going to agree, pursuant to the terms of our litigation management agreement, that you'll conduct 2 hours of depositions, not 4. That you'll do 1.5 hours of research, but not 6. That you won't do a motion for summary judgment unless you can prove to me that it's worth doing, and so on, and so on, and so on. So imagine you are a doctor, and I'm the HMO, and I can tell you what tests you can run on your patient. Are you going to run the test and not get paid, or not run the test? You're going to not run the test. Are you going to come to me, the HMO, and say, look, you're giving me 90% of my business, but I think you're handling this patient wrong, and you need to tell me it's okay to do whatever test I want? You might do it once, and then you won't get 90% of my business anymore. So, lawyers who have litigation management agreements with insurance carriers are suspect because they're human. The insurance carriers love collecting your money. They do not so much love paying claims or paying lawyers. They will hire baby lawyers who will do the work fresh out of law school. So let me tell you why that's a bunch of horsepucky. It's all well and good to have a lawyer as a lawyer as a lawyer. But just like if you have an ear, nose, and throat problem, you don't go to a podiatrist. You don't want the insurance company claims adjuster picked lawyer who does auto accidents be your lawyer on a professional negligence claim. They're two very, very different animals. And the law in California with respect to broker and agent liability is as complex as anything else you will find. And you can't mix those doctrines of auto accident, personal injury, and professional negligence. They just aren't the same. So, when an insurance company has issued a reservation of rights letter, the courts in California have said that there is an automatic conflict of interest if the lawyer that's picked has any influence on the conduct of the case, such that the issue of whether it was known or should have been known will be proven, then you get to pick your own lawyer. What the hell does that mean? If the lawyer has any influence on the fact that's determined at trial. What it really means is every time you get a reservation of rights letter, you can pick your own damn lawyer. And you can pick one that understands your business.
I just want to understand that reservation of rights letter is issued after a claim has been submitted, or is it issued when you get your policy renewal?
It's issued at the time a claim is submitted. You get sued, you get 30 days to respond to the complaint. You tender that complaint to the E&O carrier the day you get it. And trust me, do it the day you get it, because there are lots of claims made and reported policies that expire on Monday. You get a suit on Friday. If you don't report the suit, you've lost the coverage. If you report it on Tuesday, you've lost the coverage. Claims made and reported means it must be reported to the insurance carrier before that policy expires. Yeah.
In relation to that, I think I just heard that even if you think someone is talking about the possibility that you have to report it, because if you don't, it won't be covered.
Yep. So it's almost as bad as what you have just described. Policies say if you are aware of a fact or a circumstance that through the passage of time could lead to a claim, you need to report it. What does that mean? Is the angry email from a client a fact or a circumstance that could lead to a claim? It depends on how angry the email is and how specific it is, but 9 times out of 10, yeah. Well, if I reported every angry email I ever got from a client, I'd never get E&O insurance again, right? So what do? Look at the policy. Some policies say that you have to report any threat within 30 days of its receipt, or you lose coverage. Others say you need to report it timely. Others say you need to report it immediately. Okay, what does that mean? If the policy expires on Monday, there is a thing called laundry listing. And what you do on the Friday before the policy expires is you pull out a piece of paper and you list every possible threat you have received, every unhappy client's name, and you send that laundry list into the E&O carrier as potential claims. Because you have now reported it within the policy period, if 2 years later that unhappy, grumpy client actually files suit, you have reported it within the policy period that applied. So every nasty email should go in a file called E&O. Yeah.
Does it have to be in writing?
It doesn't have to be in writing, but it is a more credible threat if the complaint from the customer is in writing.
So somebody verbally tells you, well, I'm not trouble.
Well, here's the issue. How is that verbal threat going to be proven if there's ever a coverage dispute? The insurance carrier would have to know of the verbal threat and say, you knew that that claim was coming because here's the verbal threat you received. Since you knew of it and you didn't report it to me within the policy period under a claims made and reported policy, and you didn't put it in the application as a potential claim for the next year's policy, you're not covered under either one. But they have to be able to prove the threat, and they have to prove that the threat was credible. Here's the lead case. A lawyer's E&O coverage expired on Monday. On Friday, this is why I use Monday and Friday. On Friday, the lawyer got a telephone call from a reporter that said, what do you think about the lawsuit that was filed against you breaching fiduciary duties to the client? And the lawyer said, yeah, right, whatever, no comment, and hung up. New policy issued on Monday. On Tuesday, the lawyer was served with the lawsuit that the reporter was calling about. The E&O carrier said, you knew of the threat on Friday and you didn't report it, no coverage. The trial court agreed. It went up on appeal. And it took 2 of the 3 justices on the appellate court. So one of the appellate court justices agreed as well. But 2 of them said, yeah, no, that wasn't a credible enough relay of information, so the lawyer didn't have valid information of the threat. And that's why they found coverage to exist. But imagine the trial court finding against and one of the appellate justices finding against. It's that sharp a knife. Yeah.
But if you've got a small company and there's not much of that going on,
Mm-hmm.
I mean, I can see it, but if you've got a lot of agents and you've got 100 RPOs at the end of the policy, I mean, what are your rates going to be?
Your loss history is what's going to determine what your rates do. And what's your loss history? Your loss report is how much money has the carrier had to spend to defend a claim. It's not how many claims have been made. Now, a carrier is going to look at all of the emails if you send in 50. If you send in 50 and you have 50 agents, that's one thing. If you send in 50 and you've got 700 agents, that's something completely different. And the underwriting on a 700 agent firm understands this, right? And frankly, if you've got 50 complaint emails with a 50 agent firm, you've got a problem. And so the underwriting takes that into account. But double my premiums or they're going to cancel my policy because you laundry list? Not going to happen.
You're recommending this basically is good housekeeping.
It's incredibly good housekeeping, but it's also a reason that claims get denied. And it's a reason policies get rescinded. So it's more than just good housekeeping. It can be the difference between coverage or not.
Let me throw another one. And actually, it's the first time this has happened in 8 years. Situation, I have a almost 30-year background in Untitled Insurance, where we did a lot of claims, so I'm always thinking outside the box. Had a situation where it's short sale, week before close, approvals, all contingencies. Seller is canceling in order to try one more modification.
Right.
Probably not going to fly, but he wanted it. Everyone got a little scared. I sent my client, you go get legal counsel. He's not threatening anything. Buyer was not threatening anything. Buyer's agent, no one's threatening anything, but everyone went to their corners and talked to everyone. In that case, I see a lot more red flags than I want to point out and identify everybody. Would that be something that I would want to alert my E&O coverage at the end of the year as part of my housekeeping?
Who's your customer in that transaction?
The seller.
When does your policy renew relative to the seller saying, I'm going to cancel the deal?
Months.
I'd wait. I'd wait for the months to go by. If your policy renewed the next week, I'd laundry list it. Because you don't know enough to know whether it's a claim or not. And if the issue is, are you aware of a fact or circumstance that through the passage of time could ripen to a claim? You sure are.
There's nothing in writing from anyone, it's just a series of conversations. When you go to do the laundry list, of myself as the broker, do you create a summary of your recollections? As part of it, is it just a clean?
Well, you should be summarizing your recollections as you go along with the file. So you shouldn't be needing to create one in the first place. But yes, and to your point, what do you do with multiple offices, multiple agents? One of the nasty questions on that E&O application is, are you aware after having made reasonable inquiry of your agents? So it puts the onus on you to make that inquiry, or your office managers to make that inquiry. And I've seen claims denied because a fact wasn't disclosed that turned into a claim. And the rule of no good deed goes unpunished. How many brokers do you know? We're going to try to work it out. It hasn't arisen to a claim yet because we haven't been sued yet. And they don't tender. They renew the policy. In the application, are you aware of any fact? No, it's all good. Because they haven't been sued yet. Wrong. The emails back and forth get turned over with the file to the carrier. Coverage denied. Ouchie. The knight in shining armor. Yeah.
So as an associate, if the broker is not instructing us to keep them informed, and then something arises, and then the broker is denied, and we don't have coverage, and then we turn around and...
Bring a claim against the broker?
Yes.
Absolutely. Understand that all of these rules that apply to the brokerage also apply to the agent, because the agent is an additional insured.
And the fact that we didn't know is enough? Or
Sometimes yes and sometimes
right.
no.
What is our duty to know?
There's a difference in the policy between an insured and the insured. And some exclusions will apply to if the insured did something, which means if the agent did something, the brokerage still has coverage because the insured that loses the coverage is the one who did the thing. Some policies say if an insured did something, no coverage. So the broker loses the coverage because the agent did something as an insured. So you need to be very careful when you're talking about what's covered in the policy or not. Counsel is the name of that lawyer that you get to pick when there's a conflict, and it comes from San Diego Credit versus Punies Insurance Company back in the middle 1980s. When there is that conflict of interest between the lawyer's loyalty to the insurance company and the lawyer's loyalty to you with what claims are either negligent or intentional, you have the right to pick your own lawyer. And the insurance company gets the right to pay for it. It's included in your coverage. The agent can pick one lawyer and the broker can pick another, because there are sometimes conflicts of interest between the agent and the brokerage. Imagine the broker's chagrin when Susie Q says not only did she steal the diamond stick pin and turn it into a beautiful ring, but she poisoned Muffy the dog while doing it because Muffy the dog was barking at her. And so now here you are in trial, and little Louise with ponytails and freckles cries because Muffy was killed by your agent. Thanks. Indemnity cross complaints can happen a lot and probably should happen more often than not. And as the agent, you're the one who is, again, I use the phrase, the tail wagging the dog. They're all blaming you because you're the actor. The broker is just sucked into this because you work for the brokerage, and the brokerage is the thing with insurance. Okay, that's a pretty deep dive into the duty to defend, but that's only one of the three, remember? So, the duty to settle. Settlement is supposed to act as a force field. It's supposed to protect you from those claims that are not covered. The insurance context is weird in this way because an insurance company can have a duty to settle all of the claims, including the ones that aren't covered, if by doing so it protects you, the insured. And if the insurance company refuses to settle all of the claims and exposes you to liability that you wouldn't have otherwise had, it can be responsible for all of those damages, including the ones not covered. So let's go back to Muffy the dog that gets poisoned in the diamond stick pin. That's intentional infliction of emotional distress. Intentional, not covered. The parents of the little ponytailed child give you a demand for $750,000. You have a policy that covers $500,000. The insurance company lawyer or your Cumas counsel negotiates back and forth and back and forth and back and forth, and you get it down to $500,000. And you send the full amount of the policy. So you send a policy limit demand to the insurance company for payment. And it says no. Because we believe we can defend this claim for $50,000 more in trial cost, and it's never gonna win. Lo and behold, not only does it win, but there's now a $2 million judgment entered for both intentional misconduct, punitive damages, actual damages, and all of those things approximately cost. Because the little girl really does need psychological help now because her dog was, and she found it, right? It's all bad. Who gets to write that check? The insurance company. Because when it receives a policy limit demand, or any demand within the policy limit amount, for full and complete settlement of all claims, and doesn't honor it, it takes the risk of an adverse claim in excess of the policy limits. So, can that be a shield that gets turned into a sword? Sure. You get a policy, you get a demand. You tender the policy, policy is denied, claim denied. You enter into an agreement to settle the claim with the plaintiff. And the way that you're going to do it is you're going to lay down and mount no defense. They're going to march forward and present all of their evidence and claim every conceivable nickel. They're going to get a judgment against you far in excess of the amount of the policy, and you agree that you will settle the claim by assigning all of your rights under the policy for the bad faith claim to them, and they can now go sue the insurance company for bad faith. Many claims get settled that way because plaintiff's counsel can now act in your shoes and go sue the carrier for the carrier's bad faith denial of the payment of your claim and its refusal to settle within policy limits. Now, Do you think that an insurance company panel counsel is going to have a settlement discussion with the plaintiff and ask for a policy limits demand? Hell no! Would Cumis counsel do that? Would your independent lawyer protect you by going and getting a policy limit demand? Oh, hell yes. Is there a strategic advantage to having independent counsel? Yes, there is. So, the key to this, remember that. Refusal to settle within policy limits equals bad faith. Both a sword and a shield. Okay, let's go to the third one. Deeper dive. Unfair policy rescission. It makes people unhappy. It is not the same as denial of a claim. Those are two very different things. Claims can be denied for all kinds of reasons. Some of them are actually valid. To do a policy rescission, the insurance carriers take a deeper dive and they look at the finest of fine print. They'll look at each and every item alleged in the complaint. They'll look at each and every item asserted by you in your statement to the insurance company. They'll look at the policy itself and every possible exclusion that exists there. So here's nasty number one. Exclusion from coverage endorsement. All claims arising out of Civil Code Section 5678, which is the equity purchaser statute. What's that? That's a short sale. Policies exclude short sales. Some. How many brokers do you know are looking at the exclusions from coverage and understanding that Civil Code Section 5678 home equity purchase agreements equal short sales? 1 in 3, maybe 1 in 5. Where's the insurance broker explaining this to you guys? Beats me. Oh, there's one. But does an insurance company want to explain that to you? Oh, hell no. Well, we gave you the policy. We gave you a specimen before you signed the final approval. Didn't you read it before you signed it? Yeah. Here's a true story. Real estate brokerage was sued 4 or 5 times within policy coverage. 4 or 5 different complaints. The last of the complaints comes in. It's a 5 or 6 transaction series of one fraud after another, really bad agent. Is set for trial. Agent files bankruptcy. Case gets continued another 1.5 years while that gets resolved. Gets ready for trial again. And there's a thing that happens during a trial called a mandatory settlement conference. And it's normally within the last 30 days before you swear in the jury and you start presenting evidence. And the conference itself happens about 2 weeks ahead of time, but 30 days before you have to submit the statement, the mandatory settlement conference statement. And in that piece of paper, you're supposed to put all of the law, all of the documents, all of your arguments, because the settlement judge is going to be looking at all of this and getting out a baseball bat and beating people up to make them settle the case. This is why a lot of cases settle before trial. So who gets it if you have a broker that's insured? Not only does the broker and their lawyer, but so does the insurance company. Because they're the ones who are going to write the check. They need to assess risk. This carrier was particularly crafty and read the damn thing, including the lawyer's statement that not only are we going to show that the broker knew all of the things that the agent was doing, but the broker was also so negligent that we can demonstrate a pattern and practice of the broker allowing the agents to run wild, as is evidenced by this Department of Real Estate accusation and license revocation with suspension issued within 90 days of the first of the many of transactions in this lawsuit. And the carrier said, when was that accusation filed? when did the DRE do its investigation in order to file that accusation? When was the policy applied for? So do a timeline with me. January, the DRE comes and does an audit. February, the policy for E&O application is submitted. It asks the question, have you ever been subjected to discipline? The answer is no. March, the policy is issued. July, here comes the accusation from the DRE. The carrier says, you were subjected to discipline, and you didn't say so in your February application. And the broker says, that was just an audit. That's not an imposition of discipline. In fact, the accusation says, we wish to present evidence in order to have discipline imposed. The carrier says, that's a fact or circumstance that you were aware of because the customer had to have filed a complaint with the DRE in order for them to do this investigation. So you knew. Who wins? Come on. There's no wrong answer, by the way. Who wins?
I would say, monkey insurance company.
Carrier wins? What do you think? Carrier loses. Carrier loses this argument. Here's why. Audits happen randomly. Who's to say why the audit shows up? There's no fact in evidence that says the broker received a complaint from the customer that bitched to the DRE. The carrier wrote the rescission letter 10 days before trial and rescinded the policy, wrote the woman a check for $1,500 and said, thank you very much, no coverage at all, even though we've already defended 3 other claims and paid on them. You lied in the application. Because the application says, asks, have you been subjected to discipline? They said, when you get the license, you're subject to discipline. It just hasn't been imposed. But merely being a licensee means you are subject to the department rendering discipline if they find a complaint, right? Ambiguity is against the insurance company. Here's the bad faith. If the insurance company had first investigated and asked, do you have a copy of the complaint letter from the customer that triggered the investigation? Then they could have said, the complaint letter is something you knew of. They didn't do that. They said, the reason for the rescission is that there was an investigation and you were subject to discipline and you didn't tell us. Talk about the fine point of a knife, right? But the law is, if the carrier denies the claim in bad faith for a not good reason, they lose, you win. And they can't, for a rescission, reserve the right to come up with a better reason later. On a reservation of rights, they can say, here's one reason, we might come up with more once we've done a deeper investigation, and they're allowed to come back again, but not in a rescission. Why? Because a rescission leaves you bare ass and buck naked. And that's not fair in California. That's why it's bad faith. Because no one wants to be caught in the rain without their red umbrella. Or find out that their neighbor really isn't so good. Or to learn just what kind of hands they're really in. Insurance is not, let's pretend you'll have coverage. Insurance is, you'll have coverage, unless we have a really good reason why not. That's why bad faith is an equitable argument as much as it is a contract argument. Really, really important distinctions. So, what do when you think you've just gotten that kind of justice? You call coverage counsel, people who do debates, who do arguments, who litigate the issue of whether or not there is insurance coverage under the policy. coverage counsel is your friend. Can coverage counsel also be humus counsel, panel counsel? Yes, and frequently are. Because each of them are representing just your interests, not the interests of the insurance company. So, that's a lot. What do we cover? The duty to defend, and when you get humus counsel as a matter of right or not, and whether you should exert that right or not. The duty to settle, and what a policy limit demand can do, both in terms of forcing a settlement and blowing the cap off of coverage if it doesn't get paid and honored. Unfair rescissions, the fine print works both ways, all of which give rise to a bad faith claim. You now all have more information about E&O coverage claims than 99.7% of the agents and brokers out there doing this all day long, who need this stuff all day long. The red dots here means my time is up.
Very good.
Thank you.
You're welcome.
Thank you.